40 plus limited liability companies, or just one cartel. A Missouri court is going to hear a Kansas City consumers class action case. Plaintiff Damon Frost Jr. is a marijuana consumer in Missouri. He's a general contractor in Kansas City. He filed a class action this month on behalf of every Missouri resident who's ever bought recreational marijuana from Good Day Farm or any of its 40 plus affiliates. 2 weeks ago, this was just an industry lawsuit. This week, there is also a consumer lawsuit. And the state of Missouri, by its own admission, stopped checking the paperwork that was supposed to catch the structure years ago. I'm Patrick Nolan. This is Pat Talks Law. Here's what Frost is alleging. Good Day Farm, the Arkansas company that bankrolled Missouri's 2022 legalization campaign, plus more than 40 affiliated LLCs, used a web of dispensary licenses to limit competition and inflate retail prices. The complaint's own words: decreased competition, increased costs. The class Frost wants certified covers anyone in Missouri who's purchased recreational cannabis from those defendants since the recreational market opened. What he's asking for: damages back to every consumer, and quote, dismantle the alleged operation, end quote. Frost himself declined to comment. Good Day Farm spokesman called the lawsuit baseless and said the company operates in full compliance with Missouri law and will vigorously defend that record. To understand why this case is interesting, go back to 2018. That year, Missouri voters approved medical marijuana. The constitutional amendment carried a hard cap. The state couldn't issue more than 5 dispensary licenses to any entity under, quote, substantially common control, ownership, or management, end quote. The cap had teeth, it had a vocabulary. Then 2022, voters approved recreational. The new amendment kept a cap, 10% of total licenses, 22 stores, but it dropped the words common control and management. That change, Frost's lawsuit alleges, was the opening. And here's the documentary fact that makes this lawsuit land. Before recreational marijuana passed, every Missouri dispensary owner had to sign an affidavit. They had to attest under oath that their license wasn't under substantially common control with any other license. The state collected those affidavits. They were the enforcement mechanism. The Independence reporter asked the Division of Cannabis Regulation what happened to that affidavit. The agency's spokeswoman confirmed it, quote, discontinued collection, end quote. When the Constitution was amended, the rule was on the books. The form just stopped being required. The only license category that still has to file the affidavit today: testing labs. So, what does 40 plus LLCs actually look like underneath the licenses? 2 weeks ago, the cultivator lawsuit filed first attached one of the operating agreements. The arrangement it described: an outside investor formally owns an LLC. The LLC acquires up to 10 licenses. The LLC then signs a management agreement with a manager, and the manager, the document says in plain English, makes, quote, all decisions, end quote, pricing, product selection, procurement. That manager, the agreement adds, also operates multiple other dispensaries, cultivation facilities, and processing facilities across Missouri. Frost's complaint pulls on that same thread: 40 plus LLCs, one coordinator, 22 store cap on paper, 60 plus dispensaries allegedly under common direction. What does the consumer lawsuit say this cost ordinary buyers? The complaint alleges the structure limited the brands a dispensary would carry, locked out third party manufacturers, and inflated retail prices across the network. On the wholesale side, the prior lawsuit alleged Good Day Farm extracted procurement margins from cultivators that climbed from 50% before consolidation to 60% by 2025 to 65% by 2026. Money that Frost's complaint argues came out of the price at the register. The legal frame: Missouri's antitrust statute and the Missouri Merchandising Practices Act, the state's consumer protection law. The Merchandising Practices Act allows damages that can be doubled, in some cases tripled, and it allows class notification to every member of the class by mail. Two lawsuits, 2 weeks apart, same defendant. Different plaintiffs, different theories, same 40 plus LLCs. If either case survives a motion to dismiss, discovery starts, and discovery in a 40 plus LLC structure is where the paper begins to talk. If you're a multi state operator in any state with a license cap, the actionable here. Pull your own ownership and management agreements. Have antitrust counsel read your cap statute the way Frost is asking the Missouri court to read it. The form may not be required anymore. The rule still is. I'm Patrick Nolan. This is Pat Talks Law.